start in 2
Good morning, sir. We'll wait for the participants to join in and then we'll begin. Ajay, sir.
Hello, good morning. Yeah, it's audible.
Okay.
Definitely. Good morning. We'll wait.
Good morning, everyone. So welcome back to the fourth day of the lecture series that is organized by the Modern Legal Research Center. Today we have with us Assistant Professor Sir, who will be delivering a lecture on the topic of deliberating the dynamics of international law. Sir is a young research scholar, writer, law teacher, and above all, a conscious human who is passionate about meaningful transformation through academics and interdisciplinary human samvad. Sir is engaged in doctoral research study pertaining to international space law under the supervision of Dr. V.K. Ahuja, Delhi University. Since 2018, Sir is a visiting faculty for intellectual property rights law in Indian Society of International Delhi. Sir has read, researched, and published in the area of constitutional law, international law, and human rights, etc. Being an alumni of Modern Law College, we are very glad to have you, sir, for today's lecture. So kindly, students, please make the most of today's lecture. And sir, over to you.
Good morning. Thank you for your kind and generous words. I hope I'm audible. My voice is reaching to your senses.
Yes,
please.
sir. Yes.
All right. First of all, I would like to make a note that my voice may be a little low, and uh, because I have a little bad health. But recently, Principal Ma'am called and asked to do this service to this institution. So I am trying to deliberate the topic of, yes, please. A sincere request if you all mute your mics, audio systems, and it will help us to have a better bandwidth so that my voice can reach unto you. So please bear with me. My throat is bad and I'm having a severe cough. I hope I'll be audible, clearly audible to you, and I'll make maximum attempt for that.
Yes, sir. All the students, please remain on mute.
Yes, thank you. As Mahma have in the very beginning mentioned that I would like to have a humane samvad. Please bear in mind that Indian words are the words which are having a significance in Oriental philosophy have very different connotation and meaning as compared to West. In West, even though there was democracy, still the concept of debate prevailed there. But in our community, we talk about Shastrartha and discourse, where every individual will have say in the open discussions about any topic. That is why the title of today's discussion is Deliberating the Dynamics of International Law. Please bear in mind that when we talk about international law, when we use the phrase international law, we specifically mean public international law. And we do not dwell into the realm of private international law. I hope, as I was advised by your faculty members, that we need to keep this discourse, this discussion as basic and as deliberative as we can. And we need not go into the technicalities or legal jargons, etc. So today's discussion is all about public international law and how it evolved, further, how it has acquired a widening scope starting from 15th century to today's 21st century, and how we all are influenced day in and day out. Our lives are influenced by the international diplomatic actions, international instruments, which are often called as treaties, development of usages and culmination of those usages into customs. These kind of international practices are affecting your and my life day in and day out. The technology that we are using right now, it's subject to international norms, which talks about privacy in the realm of international cyberspace. I hope you are aware about the recent discussions and recent debates going on in context to privacy in cyberspace. Whenever, please take a note that whenever I'll ask you, request you to share your opinions, be frank about your views on any point. I'm always on a receiving end. We are having a discussion. It will be more welcome on my side to receive your views as well. So keep sharing your thoughts whenever I ask to do so. Meanwhile, please give me a few seconds so that I can share my screen with you all, a PPT that I have dedicatedly made for today's session. I'll share a screen. I hope it is visible to you all and legible as well. Yes, please.
Yes, sir.
Hello.
Yes,
I
sir.
hope it is slide is visible and very much legible as well.
Yes, sir. Yes, sir.
Thank you. So, as ma'am have shared, yeah, thank you. As ma'am have shared about me, I am a faculty member for IPR in Indian Society of International Law, Delhi. So today's topic, as you can see on the slide, is deliberating dynamics of international law. In the very beginning, let us have a bird's eye view about the learning objectives that we are going to have for today's session. First one is to analyze the concept of international law. As I've already mentioned, when we use the phrase international law, we mean public international law specifically. Second one is to track the factors that help development of international law.
Your voice is not clearly audible.
Prevailing economic factors, political factors, and other international
Sir?
that effectuated the development
Sir, you're
Sorry,
not
voice
audible. I think sir is having a connectivity issue. Let's wait for sir to join back. Sir is coming back in a minute, so do not leave the lecture series.
Hello. Hello. Am I audible? Can you listen to me? Yes, please. Any responses?
Yes, sir. Just give me a minute. I'll share the screen.
Thank you. Thank you. Thank you. Sorry for the inconvenience. Yes, please.
Yes. Can you see
Yeah.
the PPT?
I can see and I can read. How about others? Okay. So I think we were talking about the learning objectives of this session. Please press tab or the next arrow button so that the title of the slide will emerge. So we were discussing about how we are going to analyze from the very concept of international law to how it is dynamically being affecting our lives in day in and day out. We also, in a brief, talked about an example of privacy in cyberspace. We are also using one platform presently that we are using Zoom. There's controversies about the data privacy and identity theft or data theft with respect to this specific app and its storage server located in some foreign territory. I hope you have read about these kind of news items in recent updates. Yes, please. Anybody read about the Zoom and the controversies surrounding its data storage and privacy? Yes or no? I'm not going to ask anybody about the technicalities or technical jargons or specific provisions, etc. We are going to have a discussion in a common parlance, somewhere from a general man's understanding, general human's understanding. So these are the learning objectives for today's session. Moving ahead, please next slide. Keep on pressing the next arrow. Yeah. So in the very beginning, as I've also mentioned that we are going to have a previous slide, run your brain only. Please keep that slide with me. So in the very beginning, I would like to have your learned opinions about things. I am very sure that you are pursuing the discipline of law. It means you have analytical mind and very critical approach about the things going around you. So let me ask you, according to you, what is nation? As we are going to have deliberation about international law, what is nation according to you? Yes, please, any responses? Please run your brain, dwell into your past experiences, whatever you have read up till now, and let me know what is nation according to you from a legal point. Hello.
Sir, for me, according to me, a nation is something where common people live with common culture and like
Common
uh,
culture and
and common language, using like living like a family.
All right. So you mean community having identical sources, identical culture, or some not exactly identical, similar kind of culture, and having a
Exactly.
similar set of laws, norms regulating their conduct. Exactly. So the definition of a nation or a state per se, in the domain of international law, public international law, we do not often use word nation in a technical sense or a legal sense. We use the word state. And by state, if we go back to the Montevideo Convention, if you Google it later on, or if you go back to your basic textbooks, you'll find the mentioning about the Montevideo Convention. It talks about what are the essential attributes of state or nation. So the permanent population is the first attribute, first qualification. Second is definite territory. Third one is government. Fourth one is capacity to enter into.
Sovereignty.
Yes, please. Yes, government sovereignty, and fourth one is capacity to enter into international relations and transactions. Let's have a common understanding. Simply having these attributes entrusts a territory, a nation, with a capacity. And when we talk about capacity, we are specifically denoting to the legal concepts of rights and duties. Right? States are also having rights and duties in international legal sphere. Which rights and duties are also affecting us? Am I right? I hope you are in sync with me till now.
Yes, sir.
Okay. So moving ahead, do you think are there any international statutes like in domestic law? When we talk about Indian laws, we have certain set of norms legislated by Parliament, our union lawmaking body. Also, we have laws by our state legislatures. Do you think there are so similar kind of statutes per se in international realm as well? Yes, please.
Sir, there might be.
There might be. Okay. Any other case? Yes, please. Are there international statutes per se in the domain of public international law? Like we have statutes, acts in domestic sphere? Yes, please guess. There will be no negative marking or sanction for the deviated answer. You're always welcome to guess and apply your mind. Yes, please. Okay. So let me tell you, I like the domestic sphere. There is no single or supreme lawmaking body in international sphere. You may say there is United Nations General Assembly, International Law Commission, but as far as the sovereignty and supreme powers of Indian Parliament are concerned, similar kind of institution we do not find in international domain. So, what are the somewhat similar international instruments or international norm setting instruments in public international law? Those are called as treaties. Treaties can be of multiple types. It may be bilateral, multilateral treaties signed by different nations coming together with the aid and advice of United Nations General Assembly, with the initiative of international organizations. So There are treaties in international sphere. Moving ahead, please, next slide. Let us come to the defining aspect of international law. As you can see on the slide, I have mentioned Stark's definition of international law. Now the question is, why Stark's definition? Because it is most advanced and inclusive definition. Please press next arrow key. As you can see on the slide, Stark defines international law as body of law containing rules and principles which are applicable over states, international organizations, and individuals. A gentle suggestion from my side is, while studying any discipline of law, try to break any definition into key points or sub-points so that you can very much understand the core of any definition. Here, Stark talks about a body of law which consists of principles and rules. And such a body of law is applicable to the stakeholders, three stakeholders you can see on the right-hand side of slide: states, international organizations, and individuals. At the bottom of slide, you can see traditional vis-a-vis modern definition. What is the difference between traditional and a modern definition of international law? If we go back to the early times, maybe 16th or 17th century and up to 18th century of evolution of international law, we come across different theories. For example, noted international law scholar Oppenheim talked about states being the only subject of international law. If you refer back to the definition of Oppenheim after this session, if you search definition of Oppenheim, Oppenheim says that international law is customary and conventional rules, norms which are applicable to civilized states. Now this definition is debated and very much criticized because you can see Oppenheim's definition mentions about states as only subject, only stakeholder of international law. So just see around you. Can you say Oppenheim's definition is applicable today? Can we say that only states are the subject and international law applies to only states? Yes, please. Would you like to criticize Oppenheim or not? Yes, please. I getting my point. How Oppenheim's definition is traditional one, which talks about the state as subject of international law. Perhaps another scholar, Brierley, he also talks about only states being the subject of international law. But now, the definition of Stark, which is much advanced and which includes other stakeholders, other subjects of international law, which are states, international organizations, and individuals per se, which are also non-state entities. I hope you are in sync with me. Yes, please. Hello. Hello.
Oh.
Any response? I hope you are getting the difference between the Oppenheim and Brierley's definition vis-a-vis the Stark's definition, which is a modern one. The peculiar differentiating point between the traditional and modern definition. Yes, please. Any responses? I hope you are in sync with me. Before moving ahead to the next slide, I need to ensure that you have understood the core difference between traditional and modern definition of international law. Any response? Yes, please, in your words. Slide is before you. You can decipher the meaning. Yes, please, Aman.
Excuse me, sir.
Yes, Amit.
Actually, international law is the any dispute about the internationally among throughout and any of the country, any type of
Okay.
dispute that is come in the international law. And traditional law, that is the actually just like thinking, thought, and my privacy that is affected by the any social sites, any media that is hurt my traditions. That is the called traditional law, I think.
Right, exactly.
Yeah.
But here, specifically in context to this slide, we are talking about a traditional definition of international law versus modern definition. As
Okay.
I've mentioned, in a traditional sense, when we can say public international law was budding, it was at a nascent stage. Scholars talked about a body of law which is applicable to states only. This is a traditional view. Are you getting my point? While
And
in a modern
actually,
sense,
that is belongs from the emotion. That is the traditional law. You can say a line of actual control in the India in the at the lay. China acquired the land of that persons. That comes in traditional law. Excuse me, sir.
you're, yes, you're giving illustrations which are practically right. You're
Yeah.
talking about the practice oriented approach,
Okay.
right? But
Yeah.
we will come to that point
Yeah.
in upcoming slides.
Okay.
But for the time being, let us understand that there's only
Yeah.
one difference between a traditional and a modern definition of international law is
Okay.
traditional thinkers talk
Yeah.
about state as the subject, only subject of international law, while modern thinkers are
Okay.
talking about or giving significance to
Yeah. Okay. Actually, sir, sound is interrupt. Okay, don't clear.
we are getting certain rights from the domain of international law, and also we are responsible, duty
Okay.
bound to the norms of international law. Okay,
Okay.
so only states are not duty
Yeah.
bound, only states are not getting rights,
Okay.
but
Okay.
also international
Yeah.
organizations and individuals
Okay.
like us are also getting certain rights from international law. So this is the stark
Yes.
difference
Yes.
between the traditional and modern approach.
Okay.
Okay, so
Okay.
moving ahead,
Yeah. Yeah.
if we go deeper into the jurisprudence of international law, we can come across Oppenheim's realist theory. Realist theory talked about state as a subject, which we have already discussed.
Okay.
Fictional theory.
Yeah.
Kelsen was a proponent of fictional theory, which talks about only individuals as a subject of international law,
Yeah.
while practically speaking, not the
Mm,
realist, neither the fictional theory were right, both were
mm,
extreme.
yeah.
Functional theory, which gives us a more balanced approach, which says
Mm, mm,
that both
okay.
states and individuals are subject of international
Yes, sir. Clear, sir. Okay, sir. Clear. Thank you. Thank you, sir.
According to you, object of international law, why do we need disputes? Or perhaps the international law is all about the settling of disputes among nations. So, according to you, what can be the object of international law? Yes, please. Can you repeat?
Actually, yeah, yeah. According to me, that is the object of the international law. Sometime some any issue throughout the world. Just last yesterday, actually bomb blast in the Pakistan that near the home of the Hafiz Saeed. That is the terrorist, but near the 120-meter nearest at the home. But actually, according to that person, actually he wants to prove that he was not terrorist. So
Okay.
international law that is object to prove that that is the terrorist, that is the politics. That is a politics. So international law, international courts would be interrupt there to solve their problem. I think that is the object.
Okay, thank you,
Yeah,
thank you. So
yeah,
international law, basically, as he mentioned that the gist of his response is it is to settle international problems and secure peace and order,
yeah.
right?
Peace and yeah, peace and
Peace and
order.
order.
Yeah.
Okay, so
Okay.
you are going in the line of initial thinkers of 15th, 16th, and 17th century.
Yeah.
Okay, so the
Yes.
in the initial phase, jurists of the were of the opinion that object
Okay.
of international law is to
Okay.
establish ordered society. Why do we need
Yeah.
set of laws among nations or states? Just to
Uh,
bring up ordered society.
yeah.
But the modern thing, upholding justice,
Yeah.
ensuring justice should be at the forefront of international law.
Yeah.
And when we talk about justice, we are also talking, do not forget that in the present context, we are talking about refugees,
Yeah.
migrants who are displaced by climate change and natural catastrophes and their rights. We are also talking about the health and dignity of individuals. So these kind of justice oriented approach, providing justice is at the forefront of today's international community of public international law. So
Yeah.
from the ordered society to justice oriented society, this transition we have observed over last 500 years from 15th century to the present one. Moving ahead, next slide please.
Yeah.
So let us talk about the evolution of international law. Broadly, please press the next arrow key. There are four stages if we go as per the regional approach. If you trace the elements of, please press next arrow key. If we go to the previous slide only, previous slide only, evolution of international law. If we go to in the search of early elements of international law, we can have on the left hand side you can see the first circle ancient civilizations like Chinese, Mesopotamian, Indian subcontinent civilization, which we also often called as Harappan civilizations. If we go back to Egyptian civilizations, if we go back to these ancient civilizations, we can have certain norms relating to arbitration, mediation, which we can trace back into the Chinese civilization as well, Indian civilization as well. But let us not confuse with those kind of arbitration or norms concerning war to the strict legal norms as such. The norms prevailing in ancient civilizations were only of a suggestive nature. They did not concretize the norms of international law. We can say those were just indications that international law may come up among states. Someone's mic is hello.
Students, please mute yourself.
Someone's mic is instructing her or him in between. So after ancient civilizations, where we can trace crude elements of inter-kingdom or interstate dialogues or transactions. From ancient civilizations, we can come up to the Greek city-states. From 6th century before Christ to the 3rd century before Christ, these 300 to 400 years time we can trace back for the norms prevailing in Greek city-states. Professor Vinogradov talks about the Greek city-states practice.
Students, please wait. We'll wait for sir to join back. And please have an interactive session.
Hello.
Yes, sir.
Yeah, I deeply regret the inconvenience. I'm sitting in a rural hinterland of our state, so a lot of network fluctuation. So we
So
were
that's
talking
okay.
about.
The students are still there, so that's no issue. We understand that.
Thank you for your kind approach. So we were talking about Greek city-states and the intermunicipal kind of norms prevailing among these city-states of Greek. Moving ahead, if you come back to the Roman system of law, the peculiar difference between Greek city-states and Roman system of law was that in Greek city-states, the rules which were practiced by city-states of Greek were more or less really in context. But the Roman system of law is a system of law where more secular approach or more rational approach was practiced by the Roman Empire while transacting with neighboring kingdoms and the people, and the transaction between its own people, Roman people, and people of other, or the citizen of other states or kingdoms. Okay, so this is the big difference between Greek city-states, which was more religiously influenced in terms of its norms, rules, and regulations, while Roman system was a little bit more rational and more concrete in legal sense, where norms relating to war and peace, declaration of war, the treatment to be met to the victims of war, slaves, etc., were clearly provided in the Roman system of law. Moving ahead, in the European states, in 15th century onwards, specifically, the concept of sovereignty emerged, concept of independent states with certain attributes that we discussed in the very beginning, that is population, permanent population, definite territory, government, and capacity to enter into relation with other states. Those essential attributes of statehood can be observed in European states, and the concept of sovereignty, concept of supreme state having rights and duties to interact with other states, this kind of legal concept of state as a subject of international law, as a stakeholder of international law, can be witnessed, can be observed in European city-states. So these are the broadly four phases. I have just in a simplified manner summarized for you the geographical or regional phases of evolution of international law. There can be in-depth research in every segment of this evolutionary phase. How ancient civilizations were more indicative of norm-oriented approach, how Greek city-states were influenced by theological approach, how Roman systems are more legal in concrete sense, how European states gave rise to concept of sovereignty and independent states and the interrelationship between states per se. These broad four phases can be studied in depth in later discourses. For the time being, let us fix in our mind these four regional evolutionary phases of international law. Next slide, please. Yes. As we have seen how international law developed in a different regions in ancient civilizations to from the ancient civilizations to the European states. Now, if we ideologically differentiate, please bear in mind this is for just a better academic understanding to dwell into the different phases of evolution of public international law. You can have the five ideological phases of evolution of international law, which you can see on the slide. First is about semi-theological or the naturalist school of prevailing in 15th and 16th century. As I have already mentioned, the early thinkers were more concerned about the rights and duties of state or the nature of state, how states are bound by international laws, etc. kind of questions. They were not dealing with individuals or non-state entities. So in 15th and 16th century, please take note, the notable scholars like Vittoria, Suarez, Gentilis, and Grotius. The scholars that I am mentioning, Vittoria, Suarez, Gentilis, and Grotius, were of 15th and 16th century. The scholars were of naturalist approach. What do we mean by naturalist approach? They gave significance to the supreme law of nature, like a divine law, and they considered that some supreme law of nature dictates states to behave in certain way, and that is why states observe these kind of rules. Can you visualize? There is certain kind of supreme natural law which is dictating, which is directing the states to behave in a certain way with its people, with neighboring states. That is why states are following natural law or the international law. So by this manner, they gave this justification for coming up of international law. If you go further to 17th and 18th century, where the scholars like Pfaffendorf, Bankershock, Moser, etc. prevailed, these thinkers were more of positivist kind. What do we mean by positivist? They gave significance to better codified norms of international law. They said that treaties, which we often call as conventions, these are interchangeable words, treaties and conventions. Conventions and customary principles determine the realm of international law. So they disregarded the semi-theological or supreme divine or naturalist kind of perspective. Are you getting my point? As the time is passing from 15th century to 17th and 18th century, more rational approach is coming up. People are discussing more and more about the logical justification for international law. So this positivist phase talked about treaties and customs as a source or as a force for international law. In 19th century, scholars gave significance to practice of states. Please try to visualize the time frame of 19th century. Now, most of the territories across the globe are dominated by colonial powers. Imperialism is at its peak, and in certain regions of the world, decolonization has already begun. So this is the phase of 19th century. I'll gently advise you to have an interdisciplinary approach while studying any branch of law. While studying international law, for instance, you need to consider the political prevailing conditions, economical prevailing conditions at that point of time. For example, colonialism, which was, or the imperialism, which was the offshoot or the child of capitalism per se. So 19th century, scholars more or less gave significance to what kind of practices states are doing. What is the kind of transaction, what is the kind of norm followed by certain states while having a relation, economic relation with other states, political relation with other states, etc. So this was the practice-oriented lawmaking approach. All right. Moving ahead, the fourth phase is all about institutional lawmaking. By institutions, we mean international organizations like United Nations, Permanent Court of International Justice, which later came to be known as International Court of Justice, international labor organizations, etc. kind of international institutions dominated the norm making in international sphere. So more and more treaties were coming up, maybe multilateral treaties, like 190 plus countries coming together and signing United Nations treaties and conventions. Significantly, ICCPR, which talked about the civil and political rights of people. So the institution dominated the international lawmaking in 20th century. Now we are witnessing globalization, phase of globalization to localization. Let me ask you, anybody heard about this term globalization before? Anybody? Yes, please. Any learned mind present here? What are we? Anybody would like to share thoughts upon globalization and localization? Yes, please.
Yes, sir. Uh, uh, yes, sir. Excuse me.
Yeah, go ahead. Yes, please.
Yeah, actually, globalization means throughout all over the world, any type of the problem, any throughout the world, anything. That is the globalizations. And localization, that is a particular area, a unit area. That is the local area. Suppose one country, one state. That is the localizations. That is the difference between globalization or localization.
Yes. So, as you have rightly pointed, globalization is all
Yeah.
about intermingling of ideas, intermingling of legal rules and norms. So, we are governed more and more. We are turning towards universal kind of norms, right? We are
Yes, sir.
having universal rules. While on the other hand, recently, how many of you have heard about the H-1B visa issue of United States? Or perhaps
Yeah.
it's an international issue.
Yeah.
Anybody?
Of course. Yeah. I know. Actually, that is
Yeah.
a visa that is issued by the US, United States of America. Uh, that is issued
Okay.
by the America, and it is the time of for education purpose or job purpose. I think.
Okay, you're right. So it is
Yeah.
kind of visa granted to foreign citizens by United States Supreme
Yeah.
Authority,
Yeah.
its lawmaking authority.
Mm.
Okay, so that we can other citizens can access, can have employment and education opportunities there.
Yeah.
But the Trump's administration, if you have followed the news items, and I'll request you as a law student and specifically of a public international law, you need to follow, keep tap of the international developments, whatever are happening in and around us. Okay, so as to understand how laws are developing. Please bear in mind, as I've mentioned, the fifth phase of globalization to localization, it indicates that international law is still developing, still certain kinds of usages are coming up, which are culminating into customs, certain kind of treaties are being signed. Okay, the best example in a positive sense is International Solar Alliance, which was formed by India and France initiative. Right? Okay, so certain kind of international treaties are coming up in the realm of climate change mitigation, etc. So still international law is developing. So please keep track of news items pertaining to international law or perhaps any branch of law. So we were talking about globalization to localization. Globalization is all about universalization of norms, while localization is being more inward looking, being more specific to regions. As I've
Actually,
mentioned the example of, yes,
actually, sir,
please.
international law should be improvement, necessary improvement, because there is international court is not more stronger. That is not that is a self-centered body. But
Right.
that is not stronger. That is very weaker. So I think we should have to improve their. They have to give the power to some self decide a decision. That is the international court is managed by the United Nations, but there is no any member from the United States. And in the case of Indian soldiers, I think his name is Asutosh. That was imprisoned. That was arrested by the Pakistan.
Okay.
So that condition, then here Indian government to provide to provide the international court to issue the to give the advocate to the petition of the file to set free from the Pakistan jail at the Asutosh. That is the
Yeah,
comes through the
got your point.
yeah, that is a come in the international law, international court. That should be
Got your
we should have to strongest them international court. they should have a power to organize everything throughout the all of the world. Suppose you have the any world war, any world war, there is no power of the international court. So give him,
Right.
yeah, give him the
Okay,
power.
sorry to
Yeah,
interrupt. I got your point in a crux that you wish
yeah,
to have a strong binding jurisdiction for ICJ, International
yeah,
Court of Justice, like we
yeah.
have Supreme Court, which rules for the
Mm,
entire territory of India. I get
yes,
it right. But,
yes,
my dear, please
okay.
understand the concept of sovereignty. There
Mm,
are debates. Yeah, there are thinkers like you are pointing out,
yeah,
thinkers of your opinion that there should be a strong jurisdiction for
yes,
ICJ.
sir. Yes, sir.
Okay,
Okay,
but states are not willing to surrender their sovereignty in full sense.
okay,
Debate surrounding sovereignty is another issue which need to be dwelt
okay,
separately.
yeah,
So, what if you ask what is the biggest hurdle in making ICJ's jurisdiction plainly binding to all states? Biggest answer would be states' interest to protect their
yeah,
sovereignty. Okay, so
okay,
these are the issues which are no doubt that in coming time,
yeah,
more and more power will be given to ICJ to decide. Like United Nations Security Council
yeah,
is having a
yeah,
strong hand while implementing any
yeah,
sanctions. So this
okay,
is the trend. Moving
yeah,
ahead, so this is the trend of globalization. To globalization, more specific laws are coming up. Next
yeah,
slide, please.
yeah, okay, okay. Thank you, sir.
Yeah. So let us quickly wrap up the next slide about the nature and existence. As I've already discussed, that some of the positivist thinkers like Banker Shock and Austin talked about natural law, talked about the international law as a weak law. It is not a true law per se. They thought so because, according to Austinian theory of law, for any legal system to exist, there has to be a command, sovereign, and sanction kind of structure. There has to be definite sovereign power, but which lacks in case of public international law. That is why positivists like Austin and Bankeshop think that international law is a soft law, weak law, or not a true law per se. While on the other hand, naturalist thinkers like Grotius see that international law is a law, though there is no definite sovereign lawmaking authority, though there is no definite sanction, still international law is based on a fundamental principle for coexistence among nation states. International sociological standpoint, if we analyze, there are certain thinkers who support international law on the pretext of a supreme dictate of natural law to states which observe these kind of norms for the better coexistence of world community. So these are two different viewpoints, and the present answer to this debate would be yes, international law is a law, but we have to also accept that it is a weak law to some extent because the lack of sanction, lack of definite authority, as pointed by one scholar, the power of ICJ is lacking in certain contexts. So it is to a certain extent a weak law. But its significance cannot be disregarded because in the absence of international law, there will be chaos at international level among states. So to avoid that chaos, to sustain peace, order, and better justice-oriented approach among states, we need international law. Next slide, please. So there are three prevailing approaches to international law. First one is about Western European approach. Western European approach is dominated by having universal laws. The best illustration I would like to give quickly is about European Union. Different sovereign states in European region came together and accepted a certain set of norms. So the Western European approach is more inclined towards universalism of rules. Oriental approach, that is the approach of India, China, or Indian subcontinent, East Asia, is more to individual rights-oriented approach. So the basic difference between Western approach is giving significance to the strong institutions and states, while Oriental approach talks about giving significance to rights, duties, and justice. Third world approach is about the word. The word third world should not be understood in terms of poverty or economic deprivation, etc. Though sometimes it is misunderstood, like poor countries of the world are called as third world countries. It is not true in a pure legal sense. Third world means the third front of countries which were in a developing phase, in the phase of Cold War, the kind of nations or states which did not subscribe to either US or USSR side ideology. Perhaps they maintained their third front, like India maintained through its non-aligned movement. These kind of nations, states which maintain their independence, do not fall into trap of any superpower dichotomy or superpower struggle, are third world countries. Now, please bear in mind, unfortunately, most of these third world countries are poor. They are developing. For example, Latin American countries, African countries. So these third world countries, this third world approach is more about development, is more about bringing resources to these third world regions, access to resources, access to benefit sharing. After this session, please go and search the Convention on Biological Diversity. Abbreviation is CBD. Convention on the Biological Diversity talks about equitable benefit sharing principle. This is third world approach. Whatever genetic resources, whatever traditional knowledge from forest and medicinal plants and traditional approaches are developed, to those kind of resources, those kind of genetic resources, third world developing countries should have access. This approach is third world approach. So this is the broad overview about the approaches to international law. Please bear in mind the peculiar characteristic of these three different approaches. And while reading, please next slide. While reading any kind of news items, any kind of argument of any scholar, or if in your institution, if your professor is teaching international law, giving an illustration, apply your mind and think whether your professor is talking with the point of view of a European Western approach, just benefiting states and institutions, or is talking about the Oriental and third world approach, and question him why he is subscribing to specific, he or she is subscribing to specific kind of approach. This has to be the deliberation and kind of dialogue. Please do not have any kind of prejudice about any of these approaches. Neither Western, nor Oriental, nor the third world approach is perfectly fine. Nor any of them are flawed as such. We need to make balance. We need to extract good elements from these approaches and apply in prevailing circumstances. When we talk about the India and the international law, when we are implementing international law in Indian sphere, now the question, multiple questions might have erupted in your minds. If international law is a weak law, soft law, or it lacks the sanction somewhere, then how can we implement international norms in Indian setup? So dear scholars, you can see on the slide answer to this question. Indian executive, union executive, and union legislature, that is parliament, have specific power conferred by constitution under Article 51, Article 73, Article 253 to implement international norms in Indian setup, Indian domestic sphere. What do we mean by adopting international laws in Indian sphere? Simplest example will be Parliament can make a law, specific law, to give effect, to adopt certain international norm in Indian context. Parliament can give effect to any climate mitigation norm. It can bring up a specific statute and apply that principle in Indian sphere. Similarly, executive can enter into treaty. Please bear in mind, treaty making is executive's prerogative, executive's power. Article 73 talks about this union executive's power to enter into treaties. So, Parliament, union executive can give effect to international norms in Indian domestic sphere. It can adopt those international norms. But executive and parliament must bear in mind that such international norms should not be derogatory to, should not contravene the Indian laws, Indian municipal laws. In context to international law, we use the term municipal law, not national law, domestic law. These are the layman's terms. Often you find these kind of domestic law or national law terms used in newspapers by journalists. These are for the better understanding of layman, non-law person. But often you should use the word international law vis-a-vis municipal law which is applicable in a definite state territory. So I hope you are clear about how parliament and how executive, union executive have power under constitution to implement any international norms in Indian sphere. Now it's your task to find whether under the power of Article 73, Article 253, Parliament and Union Executive enacted, brought certain norms of international law in Indian territory, and what instances such norms were brought. On the right-hand side of slide, you can see judicial interpretations. Supreme Court can bring up certain international norms. There are multiple cases I have mentioned. Because of paucity of time, I cannot dwell into each and every. Perhaps I would have liked to dwell into the details of these cases, but let me give you a brief overlook about these cases. In the Kesavananda Bharati case, just a secretary lacuna or vacuum in the domestic sphere, in the municipal law, international law can be referred, or perhaps should be referred. In Visakha versus State of Rajasthan, which is a very famous case, I hope you are aware about the significance of this case in domestic sphere, that is protection of women from sexual harassment at workplace. This is the significance of this case. Apart from this, another significant point about this case is, in this case, Parliament brought the international principles, Supreme Court brought the international principles in the domain of Indian territory. Because they were vacuum, specifically in context to the protection of women against sexual harassment at workplace. There was vacuum about, there was no law, no legal instrument in Indian territory to deal with this issue, protection of women at workplace. So, Supreme Court referred to international instruments and it brought certain principles to domestic sphere. The famous case of Nilavati Behera versus State of Orissa, which talks about the compensatory jurisprudence. Article 9, subclause 5 of ICCPR, that is International Covenant on Civil and Political Rights. Nilavati Behera case, Supreme Court specifically referred to this Article 9 of ICCPR and provided compensation to the victims. And this is the landmark case. You should not forget this case of Nilavati Behera versus State of Orissa whenever you talk about the compensation to victims and compensatory jurisprudence. This is how Supreme Court brought the international principle of Article 9 of ICCPR to Indian domestic sphere, municipal laws. Another important case is of Chandrima Das, Railway Chairman Railway Board versus Chandrima Das, case of 2000. In this case, Supreme Court expanded the scope of Article 21. It provided protection of Article 21, which talks about the right to life and personal dignity to individuals who are also non-citizens. Chandrima Das was a Bangladeshi citizen. She was gang raped. And that is why in such unfortunate incidents, justice should not be denied on the pretext of person or a victim is non-citizen. Supreme Court widened its ambit, justice giving approach. Please go back to the initial dialogue that we had. Present objective of international law is extending justice. It is at the forefront of international community. So you can connect to this point in the Chandrima Das case, where Supreme Court referred to Universal Declaration of Human Rights, UDHR, and expanded the scope of Article 21 and provided protection of life to Chandrima Das in this case. So these are certain cases. In a Vellore Citizens Welfare Forum case, palliative peace principle was incorporated, which is a very significant principle of environmental justice. Okay, so these kind of principles Supreme Court brought into the domestic sphere, municipal laws. So executive, parliament, and judiciary all are equally empowered by our constitutions to give effect to international norms in municipal sphere. I hope I'm clear till this now. Anybody is having any doubt about this specific slide or the role of executive, judiciary, or parliament? Yes, please. Anybody? Yes, please. Anisha ma'am, I'm audible and the screen is like.
Sir, I think nobody has any doubts.
I hope. Thank you. Either so the interpretation of the having no doubts can be at two extremes. Either I am delivering to their fullest satisfaction. A second thing, they are not at all in sync with me. I don't know what is the case, but I hope the first case is prevailing right now. Next slide, please. I'm aware that we are already out of time and I need to wind up. Let's have a quick.
So we can continue till for another 15-20 minutes. That's okay.
Thank you. Thank you. Thank you. I'll try to wind up in the next 10-15 minutes. Please, next slide. So let's have a case study. Till now, in the first, the maximum part of this session, we discussed about what is the concept of international law in general sense, in specific sense, and how it evolved in different geographical regions. What are the different ideological phases of evolution of international law, starting from the naturalist, from positivist to the practice-oriented approach, to institution-oriented approach, etc. So right now, let us have a quick review about the cases. Recently, South China Sea dispute was in news, and basically this dispute is about China transgressing its territorial boundary. Please bear in mind that as we have territorial boundary, we also have certain maritime boundary where there are certain different categories are made about the internal waters, contiguous zone, economic zone, etc. So China tried to transgress its territorial limits and it claimed vast area of South China Sea. And certainly when you claim extra territories than you have actually had, or you just try to advance your argument forcefully on the pretext of being a big economy, a big state, and you try to overpower other neighboring small states like Philippines, Vietnam, Brunei, etc., then such a kind of dispute like South China Sea comes up. This is what, in simplest words, I can explain to you about the South China Sea. Sorry. So this is about the maritime dispute. So these, as one of the scholars mentioned, international law is all about settling disputes. International Court of Justice gave its advisory opinion about this dispute, but China is trying to disregard the opinion rendered by the international institutions. So this is all about the quick review about the South China Sea dispute. More and more updates will come up about this dispute in news items. Please go back, read the background of these disputes in detail, who had what kind of claims, what is the stance of scholars in Europe, in America, in India, with respect to the South China Sea, try to analyze these kind of disputes from your academic as well as practical point of view. Next slide, please. In the month of May, recently, in Arctic Sea, there was oil spill from one of the power plant of Russia. So the power plant was run and owned by biggest multinational company of Russia. But the devastating effect of oil spill, you can read it in the slide, that 28,000 tons of diesel oil escaped into Ambaranya River. And you can see the photograph as well. After this session, please YouTube and watch the reports or documentaries made on this oil spill case. Those who are interested in environmental justice or climate mitigation kind of application of laws, this is very significant prevailing case which is going right now. So what is the question from a public international laws perspective? The question is put into bold letters. Who is liable for damaging environment? Is Russia responsible, or the multinational company who is running the power plant? That corporation is responsible? Who is responsible? Let me tell you that there is international convention on the civil liability of oil spill damage. International convention on civil liability of oil spill damage. This convention deals with the liability of states and multinational companies. So certainly, this company can be held liable for this kind of damage to environment and loss suffered by the people living in the vicinity of this river. Please keep tab of this. I just want to open your mind, apart from mere academic concepts, to the practical cases going in and around us. Now you may ask, what India has, or what are the stakes of India in this dispute? Please understand, we are totally interdependent states. Whatever is taking place in any corner of the world may affect our geopolitics. Economically, geopolitically, we are too much interdependent. So oil spill and Arctic or Russian companies' liability can guide us to develop more sound environmental principles. Whenever a certain foreign company is coming to India, having environmentally disastrous investment projects, we can deal with them in a more profound manner with the help of this case study. Next slide, please. I hope many of you read about this, at least had cursory glance about this case, that is Kulbhushan Jadhav's case. Pakistan, as you can see in brief facts that I mentioned on the slide, Kulbhushan Jadhav was arrested from Iran on the pretext of espionage and spying, or perhaps spreading terrorism, in the words of, according to the arguments of Pakistan. So right now, there is a long trail of history about this case, which started in 2017. India approached the military court of Pakistan, pronounced death sentence to Kulbhushan Jadhav. An entire proceeding was conducted in a very, very opaque manner. There was no transparency. Suddenly, one fine morning, we came to know that our national, Kulbhushan Jadhav, was arrested from certain place, who asked to be a ex-veteran of Navy. And now Pakistan is claiming that we have arrested this person on the charge of espionage, spying. And on the international platforms, Pakistan tried to lower the image of India. because India is one of the leaders in Asian continent and on the global platform as well. So Pakistan used this use this opportunity to scandalize and to lower the image of India. Now, and it denied the consular access. What do we mean by consular access? A person is appointed in all the states who has to take care of certain legal proceedings about his nationals. For example, if in Pakistan a case is filed against an Indian national, that consular office has to take care that the concerned person gets access to fair trial. Concerned person is represented by legal counsel. So these kind of facilities which are also provided in under our constitution, the person had to have a right to be heard. But in case of Kulbhushan Jadhav, the entire proceeding by military court was carried on in an opaque manner, and that is why India approached International Court of Justice. Some of the scholars talked about the lacking force of International Court of Justice. Yes, because the principle of jurisdiction of ICJ is that both the disputing states have to accept the jurisdiction of ICJ. Then only ICJ can pronounce verdict. So please keep tab. ICJ, the current status of this case is that till 5th of October, the High Court of Islamabad has asked Indian authorities to appear and to give a legal support to Kulbhushan Jadhav to represent him before the concerned High Court of Pakistan. But India abstained from appearance because it says that if we appear in certain High Court of Pakistan, then we are accepting the jurisdiction of that High Court, which is not the case. We are accepting the jurisdiction of ICJ only. So this is the present ongoing debate. You need to keep track of the developments. This is very, very interesting case as far as the individual rights, security, geopolitics, these kind of overlappings are concerned. I hope you are clear about the brief facts and the present development of this case. Next slide, please. This is another interesting case of Chagos Archipelago. Archipelago, in a geographical sense, means a small islands, a very, very, very small islands. So, if I tell you that there are certain islands or certain territories in the world which are still under colonial powers, would you believe that? But interestingly, Chagos Archipelago was under the colonial power of Britain. And this is the bone of contention which gave rise to this case. When Mauritius got independence in 1968, United Kingdom, that is British colonial power at that time, did not give away Chagos Island to Mauritius, which has to be the actually Mauritius territory, geographically speaking. But United Kingdom did not give away the claim over this territory. Perhaps, as you can read in the slide, United Kingdom leased this territory to US for the strategic and military purpose. Recently, in 2016, the lease agreement was extended, and that is why Mauritius, which is a very, very small nation, state, approached ICJ for its advisory opinion. Highlight the word advisory opinion. Okay, so this is one of the drawbacks of international law, that ICJ has advisory opinion. Unless and until United Kingdom also accepts, please be clear about this thing. Both the parties have to accept the jurisdiction. When United Kingdom also accepts ICJ jurisdiction over this specific case, this is case-to-case approach. Okay, so if United Kingdom accepts ICJ jurisdiction in this case, then the opinion of ICJ will be binding on both United Kingdom and Mauritius. Interestingly, ICJ gave advisory opinion that Chagos Archipelago should be returned to Mauritius. Now, though this advisory opinion is not having any binding force, still it is having political repercussions. Please bear in mind. Please take note of this fact that ICJ's opinion is having effect on international geopolitics. UK will be pressurized by international community to behave democratically to behave democratically and return Chagos archipelago to Mauritius. I hope you are clear about this case. This is about right of self-determination. This case is about right of self-determination and democratic principles on international platform. Next slide, please. This is another famous case of Enrico Alexi, where two Italian Marines killed, shot two Indians who were traveling on their own boat off the coast of Kerala, 20.5 nautical miles from the Kerala's coast. The argument given by the Italian Marines were, in their defense, was that they considered these Indian fishermen as pirates. And in just self-defense, they shot these Indian citizens, Indian fishermen. In this case, Permanent Court of Arbitration gave verdict that Italian Marines should be returned back to Italy and case should be dealt under their jurisdiction. There is strong difference of opinion between Italy's approach and Indian approach. That jurisdictional aspect we need not dwell right now. But the only takeaway point of this case is international law is coming to the rescue. International institutions like Permanent Court of Arbitration are coming to the rescue of individuals like fishermen. They're protecting fishermen on high seas. Yes, please. The present status about this Enrico Alexi case is Italian government gave compensation to families of fishermen, and families of fishermen have accepted that compensation of 10 crores. And right now, the case is settled out of court. The last case study is about recent, very burning issue. One scholar mentioned about the issue of Israel-Palestine as well. This is very, very complex geopolitical territorial issue. Also the issue of right to self-determination. Israelis, Jewish people are claiming their own land or the greater land, while Palestinian people, Arab supported by Arabs, Egypt, are claiming their own right over certain territories of West Bank, Jerusalem, which is a city, holy city claimed by both Jewish people and Arab people. So this is a very complex territorial issue. In a simplest manner, we can decipher this issue as two different groups, one supported by Arabs, Muslim world, and another Jew people of Israel are at loggerheads over certain territories of West Bank, Gaza Strait, and Jerusalem. United Nations tried to intervene in this issue, but still, in a recent incident where bombing was unfortunate, very, very unfortunate incidents of bombing was carried out by Israel, and world community could not help out. So this kind of terrorist activities or this kind of territorial disputes are also subject matter of international law, international institutions like United Nations, regional groupings of countries like SAARC or European Union, etc., have to come together and resolve the prevailing territorial disputes like Israel and Palestine. So these are the current case studies which you need to keep track of while trading newspapers. You need to understand where is the Oppenheim's definition applicable, where is Stark's definition applicable, where is Oriental philosophical approach is followed. where is the right approach, where is the Western European approach followed while reading these kind of current burning issues. So come out of the black and white letters of your reference textbooks and follow these kind of updates and try to connect these updates with your routine discussions about law, maybe municipal law like constitution, civil or criminal law, or international law, or the other branch of international law, that is private international law. So this is all about the public international law. In a minute, I'll summarize. We started from the very beginning of concept of international law. I asked you, what is nation according to you? Then we discussed about the concept of state in public international law, about Montevideo Convention. Later, we also talked about, we also discussed the evolutionary phases, region-wise approach from ancient civilizations to European states. Then also we discussed about the ideological transformation, starting from the naturalist thinkers to present day globalization to localization approach. Later, we also talked about whether international law is a true law or not. If not, then why it is not. If yes, then why it is true law. Whether it is a weak law. Yes, it is little bit weak law in terms of lack of sanction and authority of ICC. Moving ahead, we also discussed about different approaches to the study or practice of international law. Three significant approaches we discussed. Then we discussed about how international law is implemented in Indian municipal jurisdiction by Union Executive, by Parliament, and by Supreme Court. Later, we also discussed different 5 case studies. In a brief, due to paucity of time, I couldn't dwell in detail of these technicalities, but I have tried to share the general approach about these case studies, and I wish to emphasize on the fact that you need to keep tab of these kind of international developments. Try to connect the concept discussed in your class to these kind of international news items. Try to apply. A law student has to have application kind of mind and has to have analytical approach while dealing. So that was my prime aim behind sharing these recent case studies, some of which, like Enrica Lexi, got settled. Kulbhushan Jadhav, how many years it will take for international community to settle these kind of international disputes. But with the help of these case studies, we observed that the object of international community is to ensure justice among nations, among individual states. I hope that's all from my aim, and I have conveyed whatever I could in a little available time. And amid this frequent interruption of this technical glitch, I hope I have tried to convey the basics of international law, public international law, and its practical approach that we need to keep in mind. Though this is very, very complex branch of law as far as its evolution and scattered sources are considered, but I have tried to make it as simple as I can. And I hope you'll take certain points from this and you'll develop your understanding about public international law in coming time. For any kind of queries, any kind of further discussion, you can mail to me and you can get my contact number from Manisha ma'am. I'm always available for any academic discussions, dialogues, and assistance. That's all from my end. I sincerely and humbly thank you. Modern Law College and the authorities of this institution and the faculties, Manisha ma'am and other, these kind of active events, despite the limitations of pandemic, which are like a food for thought. I know there are very much limitations of these international internet platforms, but I also hope that in coming time, in a physical environment, in institution will give me another opportunity where we can dialogue, these kind of debates can carry it on further, and we can have a constructive samvad for better and meaningful existence of all of us. Thank you. Have a nice, meaningful day.
Yes, sir. Thank you so much, sir. There is a question in the chat box.
Yes, please. I'll read. Just a minute.
Is there any case study regarding?
Any case study?
Yeah.
Is there any case study regarding international data security of people? Why do we forget the Puttaswamy case itself? If you have microscopic reading of this judgment itself, you can see Supreme Court referred to many ongoing international debates, international norms relating to data security. Like recently in European Union, there was a specific international instrument which when we can say it is more or less regional in approach, which tries to secure the data related rights of citizens of European Union. Supreme Court referred to that kind of international instrument. It emphasized that individual dignity is transcending beyond the physical limits and physical boundaries. So we need to ensure that the individual dignity and privacy is maintained in international internet jurisdictions and cyber jurisdictions as well. So if you read finally the judgment of Puttaswamy, you'll find that Supreme Court referred to certain international norms. So I can see at this moment, this case comes to my mind so that you can refer it in both Indian municipal context and in international context as well.
Yes. Thank you so much, sir.
Okay.
If there are no other questions, we can continue with the vote of thanks. Yes, does anybody have any questions?
Ma'am, I would like to ask one question.
Okay.
Okay. Hello, sir. It was very informative lecture. Thank you. Sir, can you please elaborate on career options available in this field of law, and especially in India?
Thank you. Yeah, I was expecting this question because whenever we discuss international law, in the very beginning sessions, we have dialogue about the international law, its significance or its applicability. Scholars often ask about career opportunities. Yes, you can practice international law before international forums. Second option is you can join the services of United Nations. If you refer to the United Nations website or the website of UNESCO, WHO, IMO, you can find general and specific services where legal services, specific exams are conducted for legal services under these international organizations. Legal officers, consultants, project officers, researchers are recruited by international organizations. So this is another kind of opportunity, which is a very good opportunity where you can work across the national frontiers and can understand the municipal laws of different nations. There are certain regional groupings which are involved in like SAARC, where Indian government is having representation. Research and development is also carried on under the mentorship of these international associations. The research and development in these kind of associations is another opportunity. Academics, sharing thoughts about, sharing understanding and knowledge about international law is another branch. Newer and newer branches are coming up, like international space law. You'll be surprised to know the first satellite was launched in 1962, Russian Sputnik. But 5 years prior to that first launch of satellite, one Canadian institute, a famous university, McGill University, started PhD study in international space law prior to the technological development. Why I'm sharing this illustration? Because academics has to be a step ahead of technological and economic developments. Unfortunately, in India, we are still struggling with this kind of attitude. I hope in coming time, young scholars like you will take up newer and newer avenues and will explore more new areas. So academics is another option. These are some options which comes to my mind at this point related to career in international law. I hope I have
Yes, sir.
conveyed clearly. Okay,
Thank you.
thank you.
Thank you so much, sir. Firstly, I'd like to thank you for giving such an insightful lecture,
My
from
pleasure.
introducing what a nation is to understanding their roles in international law. Sir has properly explained to us the role of India in international law using appropriate tools of case studies as well. So I suppose that after today's lecture, everyone has a proper extensive understanding, not only of the subject of international law, but also about the careers that can be taken up after studying international law. So we look forward to such endeavors in the future as well. Thank you so much, sir, for your valuable time. And thank you, participants, for being present. Tomorrow's lecture for the guest lecture series is going to be at 3:30 in the afternoon. Thank you so much.
Thank you. Thanks a lot.
With this, I conclude today's session. Thank you, sir.
Thank you.